I do not want to, as I said in the tape, I do not want to run the kids back and forth between father and mother. Besides that, if it turns out, this is quite a realistic aspect for me, is that once she has uprooted, changed her whole life by 180 degrees, walked out on the husband with the kids and gone to a hostel, if she has attained something positive, perhaps for the first time in many, many years, I'll be damned if I'm going to take it away from her. You have to understand that
take it away from her in the sense of?
By forcing them all back together again, if I can possibly avoid it.
Let me ask you a further question about the exclusive possession issue, and then I think we have a question in the back. If you've said that best interest of the children is something that's paramount to you, the statute also mentions violence as one factor that you should consider in ordering or considering whether you're ordering exclusive possession. In this particular fact situation, if wife's counsel had, for example, been able to take a couple more days and come up with some corroboration of the death threats, for example, 10-year-old son saying to his teacher, yes, daddy has said that, and teacher making an affidavit saying, yes, child is concerned about this, said his dad has said that. Is that sort of thing, would that have been significant in this? Would it have been determinative?
My dear lady, and all the people here, I kid you not, I will never turn down any admissible evidence from any source at any time. Please, I beg of you to understand that. I play with real live people, as I mentioned, like little tin soldiers. It's a heck of a responsibility. I grasp at any evidence, any insight as to who these people are. How did they ever appear on my doorstep? And believe me, yes, overwhelmingly, yes. What I do with that evidence, I will tell you right now, I leave up to me, all right? That's the way the system works. But don't ever think that I don't take all the evidence fundamentally that's given to me most seriously, most seriously. I recognize there have to be conflicts, that's the nature of the business we're in. And conflicts on facts, let alone truth. Little small matter sometimes creeps in. But the grasping towards evidence. So many times people will come to me and say, well, it hurts, and please, will you please fix it? And that's really all they're telling me. It hurts, please fix it. That's not the way the system works. It works on evidence. It works on fact. And as far as I'm concerned, you, I suppose, can, in some senses, be criticized for over information, but very, 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 very seldom, and only in the weirdest cases will you kill a tree for your client type of thing for the paper involved. But I, as I say, every party is. I meet everybody. They deserve each other. I meet them halfway. But the way to do that is through what you people will tell me as the facts of the situation. So yes, madam, overwhelmingly, no matter where it comes from. Let me figure out what to do.
It's a question down here.
Madam.
Pick up on a comment that Alan made earlier. How is it then that we can create a context for our particular fact situation as well, when we can demonstrate to you or other judiciary that have come before that the battering has had an extremely adverse impact on our client and their children, that there are many good reasons why they stayed in this relationship, but there are many more good reasons why they're the ones who have had to leave to run for shelter. How can we make that context for you on a particular application? How can we also inform better you and your colleagues who don't come to any of these seminars why women stay and why they're adversely affected by it?
Yeah, I know. How do you do it? It's difficult to suddenly show up and say this life of the last 15 years is actually not a life at all, but a cause of action. I agree with you. I agree with you, madam. It is a very difficult thing for you to do. one obvious way, if you had the ability, financial ability, of course, and the time, would be to introduce evidence by way of a psychologist, perhaps, who has examined the wife and the children and shows these things. I mean, that's one way. Another way, and it is so difficult to know how this evidence would turn out to be. Another way might be, just off the top of my head, perhaps the close relatives of the battered victim, not the children, but the parent, showing or giving evidence, making comment, practical comment, visual, acceptable, admissible comment on such things perhaps as mental attitude. Do you see? Because that's the key to this whole thing, really, is mental attitude or mental ability, or I'm not just sure how you want to define it. I have no expertise in this at all. But there are some people who just go through life this way. This is their life. They're battered. It's just like breathing. Doesn't everybody get battered? You know what I mean? How do you present that person to this court? I don't know. That's awfully hard to do. Awfully hard to do. It becomes almost then not a legal matter, but more of a public health matter. Do you see?
Well,
it's an awfully hard question to answer.
Karen.
Yeah, I just want to double on the comment earlier the fact that you would not, per se, accept that battery was going on an adult spouse, assume, therefore, that batterer is incapable of parenting. And I have some concerns about that, and I understand generalizing can be a problem, but it strikes me that if you find the fact that there is battery that has been carried on by the male against the female, I have some concerns about the demonstrated loss of self-control by the batterer. What needs exist in the batterer that allow this loss of self-control? How that cannot translate into much weaker being children in marriage, and how that cannot automatically, or almost automatically, represent a person who has already demonstrated a lack of self-control serious enough that an adult is going to stand up to it. How then can that person possessing an inability to control himself not be putting children at risk?
Madam, answering your question, perhaps I can put it this way. I certainly sympathize with what you say, but I don't think I can inadvertently create a rule of law which, in effect, has that nailed down, that consequence nailed down.
So you'd like some expert evidence?
Well, first of all, you must understand that many children live in their own personal Beirut. All right? They live in a war zone. They cannot remember ever not living in a war zone since they were weaned. Are those children then necessarily adversely affected by the fact that they live in a war zone? I suppose, yes, they are, but it depends on what you use as your criteria to compare them with. Do you see? Simply because a child or children live in a war zone in the family does not necessarily mean it all has to be bad. There's some people out around in society today who have graduated or survived living in a war zone and are not all terribly bad for it. Nor do they necessarily, and I lean on that word, necessarily have to start battering their spouses to keep the old family traditions going. So that's one side of it. The other side, however, which I am starting to see, people are catching on to this, is the observation of the children at school when they become somewhat exceptionally aggressive. And I've had a little bit of a run now in the last little while where council have been sending me affidavits or comments made by teachers directly or indirectly that little young Johnny is showing signs of sort of unusual aggression is one of the symptoms. I had one once where the kid kept on falling asleep during school too because it was war at night kept him up. But you see, this is a little bit of illumination of the effect on the child. Do you see?
Can I stop you there, Master
Yeah.
Cork? When you, for example, get an affidavit from Johnny's teacher saying in the last year Johnny has become more out of control and is more aggressive, and you have Johnny's mom saying Johnny's dad beats me up once a week and Johnny has witnessed this, would you possibly draw a conclusion from that Johnny's dad's behavior is having a bad effect on Johnny, or would you be looking for something more? A psychologist who would say children who witness this
I think
act
then,
this way.
no, at this point then, as far as I'm concerned, the onus would fall on the father. The onus would fall on the father to say why Johnny's doing it that has nothing to do with the alleged battering. Do you see? In other words, kids, the very fact that the comment is made means that the child is out of the ordinary. Why is the child out of the ordinary? It can be something I don't know, genetic. It could be something from his diet, like these kids who eat the red dye and get all hyperactive. You pick up the damnedest things in this business. But quite often it is the simple fact of the environment in which they're living. And I am perfectly prepared to meet that supposition halfway. Simply because I can't afford to take the chance to the contrary. You see, evidence is an interesting thing from my viewpoint, but sometimes with my discretion, I can pick up a little piece of evidence here and drop a little piece of evidence there. And evidence also can be the key that gives me an ability to do what I want to do. Don't worry, you see, I don't run the law. I am just as much under the law as everybody else in this room or before me is. Don't ever forget that. I am a creature of the law. So never forget that what you're giving the master or the judge gives that person then an ability to do that which you want him to do, which he or she may want to do, but can't do because there's no bloody evidence.
Let me just, sorry, before we get to your question, let me just take it back to the question of exclusive possession in a situation where battering is alleged. Master Cork, what's the most common deficiency, let's say, that you find in the materials or in the argument of counsel for the wife who's asking you to put the husband out of the house and put her and the kids back in?
Well, it's fundamentally economic, and that is that if I kick the husband out, and he presumably has an equal proprietary right to the house as well as his wife does, it's a question of alternatives. If the counsel doesn't tell me that the husband has at least his own mother and father living within 6 blocks of where he lives, and he used to live there, and it's a young family, and the room is still empty, I can't go on the basis. I mean, I'm not an uncle to the family, the old concept that I live with. That's one thing. In other words, alternative accommodation.
For the husband as well as for the wife.
Yeah. Well, I work on the basis that if I can ease the husband out to go back or to go with someplace else, that fundamentally it is much better in the fullness of time for the mother and the children, as in this case, to go back to what they perceive to be, they being the children perceive to be their home. Don't forget, the mother has got an experience living with her parents or on her own after that, and finally they get married and they get into this mess. But the children themselves, only presumably at the age of these kids, regard the house in dispute as being the only dwelling those kids have ever had as a home. And so there's a great empathy I like to think at least empathy with those kids in that predicament to try to get them home. And in the fullness of time, I think I do a better thing, because once the father's out, the mother and the children are back in. The children's mental balance, they have learned something, of course, and that is that the world can blow up in their face. But they've also learned that not only does the world blow up in their face, but they survive it. And now they're back home, and that little incident is over, and they have survived it. That's a learning experience. Good for them, because they're going to have a lot more in the fullness of time, especially with parents like they've got. The mother, I think, assuming as I do in a battered wife syndrome, that the mother has this is something which she has spent 10 years getting up nerve to do. She's finally done it. She at least has achieved something. She has, quote, won, end of quote, in her own mind. This will assist her in probably handling the rest of her life without her husband. Finally, the father's out. He probably feels much better about it because he knows I'm right about the first two. And it's going to be cheaper on him because the wife will be able to reorganize her affairs and get her life in order now that they have finally separated. He's relieved because he's got somebody to blame. He's got me. So the end result is that everybody's happy, but they just don't know it. So they go to the Court of Appeal.
There was a question down here.
Yeah, that's right. I picked up a point you made a second ago. You said you have the ability to pick up evidence here and drop it there, and it seems to me from the videotape that one error that the applicant's lawyer made was perhaps not putting in the evidence as to the length of time that the battered wife and the children had left in the shelter.
Got a point.
Had it been that evidence had been put forward, in other words, perhaps this is the reality that maybe we only had a week left of that, perhaps it would have been.
Well, yeah, but you see, I've been around too long. I know that although it may say it on the front door, you got to be out in 30 days or 60 days. I know darn well they won't turf it out. They'll send it to another hostel. So I'm not effectively, yes, you're right. I stand to be corrected, but I seem to remember once somebody told me that there are times when all the hostels are full. In other words, the whole hostel business suddenly booms. I think it's something to do with the moon or the fall or the spring or something like that. All hell breaks loose. And so then it's a very real practical sort of a thing. But by the same token, I've had all sorts of wives and children who go as far away as Guelph and Milton, and that's if there's space out there. But bless them, the people that run these hostels have been given the spin-off of the insoluble problems that I'm trying to handle, and they're doing the best they can with what they've got. But they'll never turf anybody out in the street. I bet you most of those people sleep out in the street themselves before, give them their own beds before they turf them out. But it's a good example of lack of forethought as to. I say this so often. Don't ever forget that the evidence that you give is intended to be read and inform. It is not simply a complicated rite of passage to get an order. Does that make sense?
Okay,
I want to make a point from Hamilton, and it seems any time I've faced this situation, I'm told by my client basically there's 3 days.
Oh, true. The hard line is there. The question is at 6 o'clock on the end of the third day, there is not a moving crew come in and turf them out the door. That's all.
there's a couple more questions. I do want to be able to have Master Cork talk with you about those if we have time. I'm going to move on, though, to Sergeant O'Halloran, just because I'm afraid that given the time we have left for this program, you won't be able to hear anything from him, and I think you want to. And then maybe if at the end of that there's some more time, we can go back to the issues that we've been discussing, because there were a lot more that I had hoped us to be able to talk about. Sergeant O'Halloran, if I understand correctly, it's your office, at least in Metropolitan Toronto, that we as family law lawyers would contact if we, for example, want the police to assist us in enforcing an order that says the police should apprehend Belinda and turn her over to her mother, Jane Smith. Is that right?
That's correct, yes.
All right. And it would also be your office that would handle at least queries or complaints that we might have about charges being laid or not being laid against individuals who violate orders for exclusive possession or restraining orders.
Right,
Okay.
or I could refer you to the proper investigative office in the city, depending on where the person lives.
Okay.
Yes.
But, and if I could just round this out, at least the Metropolitan Toronto Police take the view that it is not their job to be the frontline peace officers who will initially put an applicant back into possession of a matrimonial home. If I get an order saying Mrs. Smith should have exclusive possession of the matrimonial home, you take the view that it should be the sheriff's office who does that, right?
That's right. We will go and stand by and prevent a breach of the peace.
Okay. Sergeant, let me turn first to the whole question of orders that we might obtain saying that Mrs. Smith is entitled to custody of Belinda and that the Metropolitan Toronto Police should apprehend Belinda and turn her over to Mrs. Smith. In your experience, what are the problems that you've seen in terms of enforcement, or the police perceive in terms of enforcement with those orders and the types of orders that solicitors come to you with?
Okay, if you intend on calling us for assistance in the execution of your orders, we would like you to be specific in your language on your order and direct us, have us directed to act on your behalf or with you. The Metropolitan Toronto Police Force or the Ontario Provincial Police Force or whatever, the Hamilton Wentworth Police Force. Make your language direct and preferably in terms that we can understand, which we sometimes have difficulty with some of the legal terms.
Is it enough to say Metropolitan Toronto Police Force, or does your office take the view that a specific officer should be directed to act? My understanding was that was the legal advice you received.
Specific officer, Inspector Dennis?
Such as Inspector Dennis.
Yes, but as long as it says the Metropolitan Toronto Police Force, we're happy. If it doesn't say anything, it doesn't even mention the police force, that's when we have problems.
So, for example, if it just says peace officers, you're going to be reluctant to, or you're going to see a problem.
Well, we'll
in terms
have
of
some
acting.
questions and make some inquiries before we do act, and of course, as you know, sometimes time is vital.
Yes.
Can I ask a question? I'm fascinated. I usually give an order that says all police and peace officers, but I don't geographically define the police department that may end up with the child, simply because many times you don't know where the kid is.
Yes, in those cases, you'd have to word it very generally, sure, but if in a lot of cases you do have a fairly good idea, we would ask to be named. We specifically ask to be named because you're showing the difference between a 37-1 custody order and a 37-2 custody order. Of course,
You're referring to the sections of the Children's Law Reform Act?
right.
All right.
And a 37-1 order just allows an apprehension to happen by the applicant, the wife, usually. We get them come into the station, and our position again there is because we're not named specifically to do anything. As a matter of fact, in those orders that I've seen, no police department is named to do anything. We will go and stand by and hope that everything happens the way it's supposed to, because our position is that if it doesn't, it's akin to peaceable possession of an auto by a bailiff. Don't pay your card bill and somebody comes and reefs your car out of the driveway at 3 o'clock in the morning, and it's a private bailiff that does it, not the sheriff's department. If it's a private bailiff, if you say, no, I don't want my car to go, that's not peaceable possession. So as far as I'm concerned, the tow truck driver doesn't get the car. In your case, if it's a 37-1 order and I'm not named to do anything other than stand by, I can't. Versus a 37-2 order, if you read the section, it gives me power to enter, search, conduct investigations, use as much force as necessary to to execute the order.
Should there not then be a defined, acceptable, universally acceptable phraseology, which would have it under the subsection 2, obviously, because that's the broad section, and that would be acceptable to all police forces, whether or not they are defined, as it were, geographically in the order. You have to understand, you see, the problem is getting the order. They're not given quite like green stamps, and the end result is that you've got to run back and forth, trying to, with affidavit material, getting some judicial somebody like me to sign an order, depending then on the circumstances as they are breaking, as it were. You know what I mean?
I've had those discussions with other people in Sergeant O'Halloran's office, Inspector Dennis, who heads up that office, and in fact, in the materials you will find a draft order that I believe at least meets the requirements of the Metropolitan Toronto Police with respect to this.
And I look.
It's at page C30. And I understand that this form of order meets most of the problems that the Metropolitan Toronto Police have had with some of the orders they've been seeing. So if I can just recap what you were saying, Sergeant O'Halloran, because it's only Section 37.2 orders that give you, for example, specific powers of search and more specific in powers to look for a child, an apprehended child, and because 37.2 orders say that a police force must be directed, your police force at least takes the view that the Metropolitan Toronto Police should be named in the order.
Yes,
right?
That's correct.
Other problems that you've seen in orders that you get directing you to apprehend a child?
One of them that's just covered in the one in your package has an expiry date on it, 37/7 of the CLRA says that an order must have, it says that an order shall name a date on which it expires. There has been the position of some of my predecessors in the office that if an order comes in and it doesn't, it's not a legal order, so it goes back to be amended or changed. That's a little hard to do, or it's hard to explain to the wife who's crying at the front counter of the police station that we can't execute the order because we may not think it's a lawful order. So, and the expiry date, the inclusion of the expiry date clause, which is in the package.
All right, and just following the wording of Section 37.7, it would be sufficient that it just said that the order would expire 6 months from the date of the order.
Right.
All right.
Because all the orders are dated, of course. No
In other
problem.
words, the date from the time of the order, you are obliged, if the order says so, to enforce and recover the child within the period of 6 months, after which automatically the applicant has got to come back to the court and start all over again.
I would believe so, yes.
Do you have any facilities for providing counsel with evidentiary material as to what has been done in that first 6 months unsuccessfully?
Oh, yes, I would be able to come up with like a fact sheet on what has been done to try and find the
Because it
child.
seems to me that would be the very first question that any judicial figure would be saying, well, what happened in the first 6 months, do you see?
Would sorry.
I was just going to say, be prepared for that.
Oh,
I think
yes.
Probably they're going to be asking.
No problem.
So there wouldn't be any problem from your point of view in terms of getting reports from specific divisions saying, we looked for Belinda here and here and here and couldn't find her, and going on to the next.
Officers could certainly be called to give evidence as to what they've done to try to execute the order.
Well, the problem
What?
is that it's not verbally evident,
Okay.
verbal evidence in the Supreme Court at that stage. Do you see? It's all on affidavit material.
Would there be any difficulty getting officers to cooperate in signing affidavits saying what they've done?
Well, without talking with somebody like Metro Legal, I'd hate to offer my services as a voice for them. I'd have to look into that.
Okay. Let's go
Any
on.
investigation, we have a running file on what is done. I don't see that it would be a problem to get that written material.
To the applicant's lawyer.
Yes, perhaps, I don't know, they might have to subpoena it, I don't know, or whatever.
And if we had difficulties getting that type of information from an individual division, it would be your office that was the best office to contact
Certainly,
in terms
yes.
of working that out?
Yes.
let's go on with other significant problems you're seeing in apprehend orders that you get.
There's minor problems that come up. Some of the orders come in referring to sections, which, as an example, Section 32 was repealed last year in 1987. You wouldn't have that if you don't keep your acts up to date. Some of them name police forces that don't exist. Minor things, we can get around these. Restraining orders. The one thing we ask with your clients with restraining orders, well, actually a couple of things, I guess, is that they have an original or certified true copy of it. I suppose virtually with them at all times. We have no central file for them, and I don't know whether the courts do. Well, I would imagine the courts do, but they're hard to get at 3 o'clock in the morning when there's an alleged violation. So we would ask that what we call the complainant, you I suppose would call the applicant or whatever, would have the copy with them, and if they have a problem with their husband, as an example, that when they call the police, that they can say, here's the order, and we can look at it, and then go from there.
Before we move off custody orders, I just have a couple more questions I want to ask you that have certainly come up in my practice a lot. Let's say we have the order that's on page C30 and it's all in proper form, and I'm Jane Doe's lawyer and I want to get you to apprehend the child. One, I would need an original or certified copy of that order to go to the police, right?
Right.
And then what's the procedure that you suggest we follow? I mean, should we be contacting the local division? Should we be contacting your office? Should we be sending the applicant over with the order? What's the best?
Okay, we would prefer that you or the applicant, especially the applicant, take it into the police station, preferably again the one where the kids are, if you know that, or your local police station. Don't send it by courier. If it comes into the police station addressed to Chief of Police 22 Division, everybody's afraid to open it. We take it off the desk and put it over in the outgoing mail, and it comes down to headquarters, and that takes 3 days through our departmental mail. Nobody does anything with your custody order. Take it into a police station. You or the applicant, someone from your law office, ask to speak to the sergeant or the staff sergeant, the man with the stripes on his shoulders, and say, this is what I have here, because he will undoubtedly, no matter how finely worded your order is, he'll undoubtedly have some questions to ask the applicant. Where are we going to find your husband? Is he on drugs? Does he have guns? Is he violent? Etc., etc. We want somebody there to be able to answer the questions. We will ask that the applicant comes with us when the order is executed. Okay. We don't come in on a Sunday morning and pick up a pile of custody orders and say, who are we going to look for today? We want somebody there because we'll execute the order and we'll turn the child over right there to the applicant, and then the order is executed. We've done our job. We would like a description of the child and maybe a picture, but we still won't execute the order unless the applicant is there.
Let's say I think my daughter I have one of these orders, I think my daughter is at 40 College Street, and you go there and it turns out she's not. And I think she might be in Barrie with husband's mother, or she might be in London with some other relative. What can I expect the Metropolitan Toronto Police to do in terms of carrying the enforcement of that order further?
Okay.
And looking for the child?
Well, we'll do all the things we can to verify whether or not the child is in Toronto, and then if we have information that it's somewhere else, we will notify that police force and ask them to act on our behalf.
Right.
On your behalf. I see. So that then you take over the return of the enforcement of the order, if you're named, and then if it turns out that it's in another jurisdiction, another police jurisdiction, no matter where it would be in the world, presumably they would cooperate with you, and you'd control how the other police department would do then the enforcement of the order.
Well, when in Rome, do as the Romans do. We have to go by the law that's in the jurisdiction where the child may be.
Of course.
Yeah.
Oh, yeah, I'm not...
So
well,
we're
I
talking
wasn't-
within Ontario?
Yeah.
Okay.
I was thinking within Ontario, or at least within
sure.
Canada. So that if you, could you tell the people that what they should do, as being here in metropolitan Toronto, that they make simply every order to the chief of police or this gentleman down here, the metropolitan Dennis, and then let him handle the enforcement of it directly from his office thereafter, if it goes anywhere else. Could that be done?
Well, no, because then we're going to have a problem when we execute the order. If the kid is in Barrie or Sudbury, how do we get the kid back?
Well, presumably you would act as the dispatcher to send the collecting parent to wherever that policeman is going to get the kid from the other parent, do you see? Or from somebody.
To the other force.
Yeah, precisely. In other words,
Yes.
if you could organize it so that then the parent goes not just necessarily with your people, but with wherever the kid may be.
We won't go outside of Toronto.
No, I recognize.
Unless it's just into Pickering, that type of thing, or just into York Regional. But we will make direction to another police force that we have a custody order on file. We'll send them via CPIC, the computer system, the wording of the custody order. We have information that the person is at 123 Any Street. Please go there and check. And as far as we're concerned as a police department, we're giving them reasonable and probable grounds to do everything in the order that it directs us to do.
And you'll follow up in terms of how the Barrie Police, for example, what they're doing about that?
They'll certainly notify us, and sure.
But then,
If they make the apprehension, we still have to get the parent has to get to Barrie.
but yeah, well, yes, certainly. But what I'm saying is they don't want to pick up the child and then sort of hold the child in limbo.
No.
They know an order exists, so when they go out, why can't it be on the basis of the other parent who holds the order going out with them under your initial direction and referral to the Barrie Police Department?
Well, it would
that
certainly
not
happen
work?
that way, sure.
Yeah.
Yeah.
That's what I'm saying. In other words, you may not have to go back and forth getting orders for geographic location of each individual police department if you would act as the dispatcher. And the order is to you, and then you, as far as Toronto's concerned, handle in Toronto or anywhere else where the child may eventually be found through your office. That would satisfy the order.
The only problem is that I probably can't act as a spokesman for the Barrie Police Force or any other police force. So that's why it's covered in the general wording here. That's in the example given in the package.
So it includes other peace officers that would authorize Barrie Police to apprehend, but your Metro Police, if the order originates here, are still willing to act as the routing office.
Oh, certainly.
To coordinate this.
Yes.
Okay.
Good.
And let's say I have information that I get one of these orders and I think my husband's going to get on a plane to the United States with the children in the next 24 hours. What help can you give me in that situation? Should I be contacting you? Should I be contacting the RCMP? What?
Yes, you must contact a local police force, whomever that is, whomever you choose to contact. At the airport, there is a liaison squad. It involves 4 different police departments right now, and they will bend over backwards for a police department to help them execute an order. And of course, we are acting on your client's behalf. If you try to contact them directly, you're not going to get much of a response. That's why we say take your order in to a police department. And I can make a phone call from here now saying that the guy's leaving on a plane at 1 o'clock. I have a custody order. It's in my hand. Get him off the plane, words to that effect. Here's a description of the guy. I can phone them up there over the phone, and that'll happen for me as a police officer. It won't happen for you as a counsel. You have to deal through a police department.
All right. And if in this type of situation where you need really quick action, let's say action within a few hours, to me it would make sense to contact your office, the liaison office, rather than just walking into the local police division that may never have dealt with one of these orders before. Is your office willing to at least initially take that role?
Well, I would suggest that you go through your local police station and speak to the sergeant or the staff and tell them your concerns about the airport business, and they will make the inquiries. And if you're not satisfied, then call us. The only reason I don't say call us first is we're a 7 a.m. to 5 p.m. operation, Monday to Friday. So that could present a problem to you or your client.
Last question around custody, Sergeant. If, let's say I just have a custody order saying that I have custody of my daughter Belinda, and there's nothing in there saying that the police should apprehend Belinda because I have her. But one day my husband just doesn't return Belinda from an access visit. If I call you, what can I expect the Metro Toronto Police will do?
If it doesn't name us?
If it doesn't name you, it just says Mrs. Smith has custody of Belinda. Dad has access on alternate weekends from Friday to Sunday, and it's Monday morning, and Mrs. Smith calls you and says he didn't bring Belinda back. Can you help me? What will the police do?
Okay, we'll verify the order, which you will show us. We will likely go out and try to get Belinda peaceably. Knock on the door. Can we have Belinda, please? We have a court order that says she's supposed to be with the mother now, and hope that he gives Belinda up. Because again, it doesn't order us. We can't rip Belinda out of the house. Even if we see her standing in the house at the back door, if he says, no, you're not having Belinda, then we have to tell the mother that she should contact her lawyer and go back to the court and get us an order that gives us some authority to act.
Okay.
Why doesn't
Penny.
lay a charge? Why doesn't Lynn now lay a charge with the criminal code? At which point you would then go in and get Belinda for her, wouldn't you?
Yes.
Charge for abduction and contravention of a court order?
Yes.
That would be the wise thing to do in that situation.
We could advise them of that might happen, yes. But until it happens, what is our authority to
Advise
act?
the husband that he could be charged with
Yes.
criminal code?
Yes.
When you initially go over there, when he says, no, you can't have Belinda?
Yes. Yes.
Could we, in that situation, expect the police officer involved who sees the original copy of the order in front of him and sees that Belinda is with the father in contravention of the order, could we expect that the officer would actually lay the charge himself, or is he just going to tell Mrs. Smith, you can go lay a charge?
Well, it can go either way, depending on the circumstances.
Is it just up to the individual officers?
Well, we're all independent agents of the Crown.
Okay. Is there any direction that's gone out to officers in terms of, for example, similar to the direction that you've gotten with respect to laying charges of spousal assault that says that officers should lay charges when there are reasonable and probable grounds to expect that assault has occurred? Is there any direction that's gone out to officers around laying abduction charges?
Laying abduction charges?
In contravention of a court order?
No, not specifically, not recently anyway. It's a criminal code section that's been on the books for some time, whereas what we run up against in the CLRA and the Family Law Act is, to us, it's new, and we have had training videos out on that and how to lay charges against contravention of restraining orders, et cetera, et cetera.
I hope to, sorry.
Go ahead.
I want to get to that in a second, but there's a question over here.
Assuming that my client and I walk into the police station at 1 o'clock this afternoon, and assuming that our paperwork is completely in order, and assuming that we know where the child is, how long before the police will attend and apprehend the child? How long? What is the time frame that we're looking at from the time we walk into the police station to the time we get the child? Assuming the child is in metropolitan Toronto and we know exactly where.
And you know exactly where. It should take within the hour, I would think. Every call in the city is dispatched on a priority basis. Every single one of them.
So I mean, it would be the same day.
Your best bet is, that's why another reason why your best bet is to go into a police station, because you'll grab a policeman or the staff sergeant or the staff sergeant will say, PC Smith, what are you doing? I'm not doing anything. Yes, you are. Come here. You're executing this custody order. Whereas if you wait for a car out on the street, those guys do 25 radio calls a day. Every one of them's dispatched on a priority basis.
If I can just pass on something too, Inspector Dennis, who works with Sergeant O'Halloran in Family and Youth Services, had suggested earlier that if you anticipate getting that type of order at 9 o'clock in the morning, it might make sense to call the local division saying, we're probably going to show up in a couple of hours with this order, just to give the sergeant in charge a warning so that he would have available personnel.
Or you could call us, and I didn't give you the number, and it wasn't on purpose, but it's 324 6145. 324-6145.
Let's turn to the question of enforcement of exclusive possession and restraining orders, Sergeant. One of the amendments to the Family Law Act in the past couple of years provided that violation of either an exclusive possession order or a restraining order is an offense. Can you tell me what problems the force here has encountered in enforcing those orders?
Well, not so much in enforcing the orders, but if we're going to lay a charge, we have to know what section or what chapter of the Ontario statutes, the Child Law Reform Act, the Family Law Act, has been contravened. So when you get your order, a restraining order or an order of exclusive possession, on your order it should say, it has to say, if we're to know what section it's made under, in order for us to word our information. You couldn't take somebody into court saying you're charged with murder because it's not an offense. It's contrary to the criminal code. Then we know what offense you've contravened. It has to say, we have to know whether it's what it's in contravention of.
And if I understand correctly, that problem exists because under the Children's Law Reform Act, restraining orders can be made, and under the Family Law Act, restraining orders can be made, but it's only an offense to contravene an order made under the Family Law Act. Is that right? Is that why the problem exists?
Oh no, they're both offenses.
Oh, okay.
They're both offenses, but it has to say, we have to word it on the information.
Okay. Let's say Mrs. Smith has an order restraining Mr. Smith from molesting, harassing, or annoying her, and she calls you up and says, he called me 25 times last night, threatening me until 3 o'clock in the morning. What can Mrs. Smith expect a local officer to do if she calls him and tells him this and shows him the original copy of the restraining order?
Well, you can expect that he'll act upon the order. He'll want to see the restraining order, obviously. He'll want to see specifically what act has been violated. He'll have to have reasonable and probable grounds to believe an offense has been committed, and which the wife will hopefully be able to give him. And then he'll go from there, whether he lays a charge or makes an arrest, depends on the circumstances, depends on the officer, but you can expect that he'll do something. He'll act upon that order.
Do you know how many charges Metro Toronto Police have laid for violation of restraining orders in, let's say, the past year? My understanding is that there's been a lot of difficulty around this.
I don't know specifically how many have been laid, no.
Okay.
The difficulty, it's to us again, it's a bit of a new act, and we have an education problem with 5,000 men, 5,500 men. The criminal courts seem to have a bit of a problem in pursuing charges in a criminal court that are made pursuant to a civil law. You know, there are problems.
Okay. Let's say that an exclusive possession order has been violated and Mrs. Smith calls you. Mr. Smith is sitting there in the house. There's an exclusive possession order giving Mrs. Smith exclusive possession of the house, and she has the original copy of it, and she says, well, he came to pick up the kids and he won't get out. Can she expect the officer, once he's inspected that order, to remove Mr. Smith?
Yes, as long as it's a valid order, sure.
Okay, and can she expect that Mr. Smith will be charged?
It's a distinct possibility.
Okay. There was a question over here.
Well, it could be, but again, we're independent agents of the Crown. We have to satisfy our own mind that there are reasonable and probable grounds. And as Master Cork alluded to a short time ago, we all have to work within the law, and any additional type of evidence we can get helps us build those reasonable and probable grounds. If you keep a list of phone calls, or you tape record phone calls, or...
Just if I can pass on my own experience, my experience is that no, that most officers would not treat that as reasonable and probable grounds, that you have to have something additional. Yes?
How soon is the JP available then to for the individual with their own information? I don't know if you know certain experiences created a scenario where you had the custody order and with no specific direction to apprehend, and yet you see the individual who does not have custody having the child, and yet still in that scenario, in your opinion, there wouldn't be a directive from the police department that there should be a charge laid under those circumstances where it's quite clear that there's another person directly in contravention of an order, and that sort of disturbs me and kind of concerns me. Hopefully, to remedy that situation, there would be an NJP available almost immediately for that individual to lay their own information and protect the status quo.
Well, JPs are available in Toronto, certainly on business hours, and they're on call throughout the city on non-business hours.
Certainly my experience is that in these sorts of circumstances, complainants are directed to the family court JPs who are only available during family court hours.
Is that you want to lay your private information, you come any weekday after 2 p.m. at a permanent court, you can meet with the JP. And it just doesn't seem that would quite fit into the scenario of your Friday evening at 7 evening at 7 p.m. and the child's not returned yet. I think that would be a pretty scary scenario for the custodial parent.
Yeah, I think it is. I think you pinpointed an area where there's a big gap. Sergeant, you mentioned before, you alluded to the fact that it's new for police officers to have to deal with this new type of offense set out in the Family Law Act for violating restraining orders and violating exclusive possession orders. In situations where those orders have been violated, but there's also the possibility of a charge being laid under the criminal code just because of what's happened, it strikes me that it might be preferable in terms of getting police assistance to pursue the criminal code route, just because that's a route that police officers are comfortable with. What comment do you have on that?
That would be the route we'd go. If there's a criminal charge, we'll go with that because we're quite comfortable with that. We've been doing it for years and years and years.
Mm-hmm. So, for example, if Mr. Smith is calling up threatening to kill Mrs. Smith, your advice would be lay a threatening charge. Don't bother with laying a charge that he's violated the restraining order?
Well, that would be the route that we would prefer ourselves to go. Sure, the criminal charge, show cause, some bail conditions, and then if he contravenes the bail conditions, he's committed another offense.
Francis?
Would it be of any assistance if the restraining order was more specific, so that it said, for example, that Mr. Smith was not to come within 1 block of the matrimonial home? And then I'd like to ask Master Cork, because I think all of us have experienced trying to get some teeth into the order, and you're really in a position of going master shopping or judge shopping. Because sometimes you can get it, and sometimes you can't get it.
Well, to answer my part, I've seen them where it says 500 meters of the home, as an example. So.
And in that case, is that more helpful to the police that he's 499 meters from the home and you can arrest him?
Sure, because it's specific. It's when an order is vague or we perceive it to be vague in direction that we have all kinds of problems. Problems that we have to try to resolve before we go and do something about the order, and that takes time. And sometimes you don't have time. Your client doesn't have time anyway.
Master Cork, do you have any trouble making that kind of order under the restraining order section?
Do I ever? You see, Sergeant, it is strange, but the court that I sit in, which is called the Master's Court, has got no criminal jurisdiction at all. I have absolutely no criminal jurisdiction at all. In addition to that, I have no what they call injunctive jurisdiction. That must be done by a judge. So therefore, I cannot make people do things in a restrictive sense. I can make people do things in a positive sense, but not a restrictive sense. I cannot say, I think, for what it's worth, I wish to heavens somebody upstairs would tell me I was wrong, that a person cannot go within so many meters of of somebody else's residence. I don't think I can do that, because that's an injunctive type of situation, restrictive type of situation. I suppose I could probably say that they could do anything they darn well wanted to except go within. Maybe that's the positive side of it. I don't know. Maybe it turned out to be something of phraseology. But don't be surprised if you see these vague orders come from master's offices, simply because of the fact that we have this rather peculiar, truncated type of jurisdiction to tell people not to do things. Weird, but there it is.
Just one last question. Aside from the problems that exist with the master's jurisdiction as opposed to a Supreme Court judge's jurisdiction, do you see any problem in an order being made under Section 46, the restraining order section, saying Mr. Smith shall not molest, harass, or annoy his wife, and specifically he shall not come within 500 meters of the matrimonial home? Let's say if you were a Superior Court judge.
Oh, if I was a Superior Court judge, I'd do it with a will. No problem there. But the problem is that I don't want to give somebody something which I feel I do not have the jurisdiction to give, and then have that then resolved in some kind of a real war, as it were, before various judges at expenses for everybody. And you lose sight of the fact of the purpose of the order, and you end up a whole great argument over the question of whether I had jurisdiction to make it or not, which just simply, as I've said so often, spends another year of university education for the kids. Final analysis, trying to resolve a silly issue.
Thank you. We have gone far longer than I thought we were going to. Thank you for your patience. I hope you've enjoyed it. Please feel free to ask Sergeant O'Halloran or Master Cork questions that you can here to answer before you go to lunch. Thanks.
Sergeant, did
the afternoon. And I'd like to introduce our next two speakers. First of all, seated to my far left is Heather Robertson. Heather has been a lawyer in private practice for the past 7 years. She started out as a sole practitioner together with Jerry Waldman, who you heard speak this morning, and she is now working with the firm of Gowling and Henderson in Toronto. Heather has had extensive experience representing battered women. And seated to my immediate left is Deborah Sinclair. Deborah is a social worker whose activities include consulting, training, and community organizing, addressing the issue of violence against women and children. She is a founding member of the Emily Stowe Shelter for Women and is on the board of directors of Education Wife Assault. Would you please welcome Heather Robertson and Deborah Sinclair.
The way we'd like to begin is I will take the first portion and share some information with you about my experience in working with assaulted women and their families. And then Heather will speak to some of the legal issues that she sees in her cases and her experience over the years. And then we'd like to have a dialogue with you, have opportunity for some questions or just some discussion back and forth. As Yvonne said, I'm a social worker, not a lawyer, and my experience comes primarily from having worked in a special project to deal with assaulted women and their families, which started back in the late 70s. And since that time, over the last 10 years or so, I've worked with a number of assaulted women. I've worked with a number of batterers, and I've worked a lot with the children in those families, child witnesses of violence. So that's really what I'm drawing my experience on. In addition to doing the counseling in the last few years, I've done a fair bit of writing and on the issue, as well as training for a number of interdisciplinary groups. For all of us, first of all, I'd like to see anyone, regardless of their professional background, as a potential advocate for any member of the family where violence is happening, be it the child, be it the batterer, be it the assaulted woman. And I think that is possible if we all can see what the different issues are for each member in the family. Some of the things I'd like to address first is kind of an overview of the issue, and that really is looking at some principles of practice and some values around the issue. And for me, this has become extremely complex the more I've learned about it over the last 10 years. When I was doing my training in the first 2 or 3 years, I thought that it was something to be taken seriously, the issue of violence, that it was clearly very unacceptable, but that there were some simple solutions to it. Once it was recognized and once we got it out on the table, then we could make change. And 10 years into it now, I realize how much more complex it is and how many lives it's affected. In the last 5 or 6 months, I've been working with 3 communities where women have been murdered by their husbands, directly related shelter incidents. And that has taught me a tremendous amount of the impact, not obviously only to the women who died, but the ramifications for a whole community that can happen as a result of that death. Those are 3 communities here in Ontario. Some of the values that guide my work are clearly the first one, which is that under no circumstances, perhaps with the exception of self-defense, is violence ever justified. No matter how provocative or how unlikable or how unintelligent or how inept a person may be, violence is never an acceptable response, and that's the position I operate from. In my experience in working with victims, and there's been hundreds now over the last number of years, I have never met a victim who has lied about her abuse in any way. It's much too painful an issue. It's something that she usually feels fairly ashamed about, fairly embarrassed about, very guilty about. She's already blaming herself. And if anything, my experience with her is that she tends to minimize what her abuse has been. In one way, for her own protection, it comes into play because she is terrified to really look at the horror of her life. And if she did, she's convinced that she probably wouldn't be able to function that well. So in some ways, it's a survival skill for her to minimize what in fact the trauma has been, as well as it is for the children. Much of what I talk about, by the way, for the adult victim, children also experience identically. So the whole issue of victims' credibility, which I know is a very important legal issue that you have to confront as a therapist and as a social worker and as an advocate, it's not been my experience that they do not tell the truth at all. On the other hand, in working with hundreds of batterers, it has been my experience in most cases when I first meet them, they are very much denying the reality of their abuse. And again, psychologically, that is what they need to do in order to continue doing that kind of behavior. Because again, for them, if they really looked at the damage they were causing to their families, to the children, and to their partners, they would not really be able to do what they do. So that is the first position that I operate on when I'm working with a batterer, is that more than likely he's going to be minimizing what he's done. Where it fits into the justice system is a very difficult one because there are no witnesses to this crime. It usually happens in isolation. It inevitably gets worse over time and more frequent over time. And there is seldom evidence to back up the victim's experience of the trauma she's received. And he knows this. It goes on, it truly is a crime that goes on behind closed doors. So right off the bat, within the justice system, you're confronted with the issue of who's telling the truth. And you've got one person who often is quite damaged when we're speaking about the victim, rightly so, given what she's been through, who may present as a woman who is quite hysterical, very nervous, very agitated, confused in her thinking, not sure about what it is that she wants, and you're thinking, is this going to be a credible witness in court? And then for those of you who might be representing a batterer, he usually is a much more credible person publicly, because the way he presents himself privately, and you've probably heard of that Jekyll-Hyde scenario, is very true for him. The way he has gotten by publicly in the world is to present as a fairly credible person. He usually is a fairly persuasive person. It can be a fairly powerful person in his public life. In his private life, he treats her incredibly badly, and she knows this. She knows that when it comes down to who's going to be believed between the two of them, she knows that he's going to have far more power than her in the public world. The children know this too, which is often why the children side with their dads. Most kids, when they have a choice of identifying with their moms or their dads, being the victim or the aggressor, kids are pretty smart. So they tend to side with the person, at least publicly, who has the most power in the family. And that's why it's often a complicated issue for people who are not familiar with the dynamics of violence in a family, why they don't understand how kids could turn against their mums. Well, kids do it for survival reasons, because they're terrified of what's going to happen to them if they speak out and tell the truth, which is the identical issue of what goes on for women victims. So in terms of intervention, and again, I think that this is, be you a lawyer or a social worker or a shelter worker or just a concerned family member of someone in our own families who this may be happening to, or in our own social network, the first most important thing for everybody in the family is safety. Safety and protection. As a counselor, it's been my experience, if the violence is not dealt with as the most primary problem when a family is reaching out for help, any member of the family, then any other kind of intervention is doomed to failure. Because unless the violence is addressed, no amount of focus on any other kind of work, and clearly there are many other problems that are going on in this family. Certainly the communication is poor, there's lots of other stresses, perhaps there is unemployment, perhaps there are issues around family economics, or all the pressures that all of us experience in our family are also happening in this family. But they are dealing with a double whammy because they have the violence to contend with as well. So for counselors, and there are many, unfortunately, who are very inexperienced in dealing with this issue, it's extremely important that they deal with the violence first. And most are scared to because they've had no training. They often, unfortunately, don't take it seriously, and they don't ask the proper questions, because God forbid they should get the answer yes. What's it going to do? It's just going to confront them with their own incompetence because they've not been trained to deal with it. So as a lawyer making referrals to a counselor, it's really important that you find a counselor who's experienced in the issue of violence, because you cannot make the assumption that every counselor, a marital or a family or an individual counselor, knows what they're doing, because in my experience, many don't. For a referral to a marriage counselor, which I know is quite a common thing. In fact, I think you have to make some mention of, is there any possibility of reconciliation? Is that accurate when couples come around separation issues?
Yeah, you're supposed to canvass that before commencing divorce proceedings. Yes.
And just to give you an example of a couple that I'm working with now, in fact, they're both lawyers. She has been assaulted by him. I only say this because this is the most recent case I'm working on, not because lawyers happen to be any more, have this happen to them than any other work. I've worked with social workers as well. We all come from all backgrounds in terms of this issue. Anyway, they went to a lawyer around the issue of looking at some kind of an interim separation agreement prior to their separation. And of course, the lawyer was quite responsible and made a referral to a counselor who he had used many times in the past and had done really good work with other couples. But unfortunately, the counselor in this case that he referred them to was not that experienced with the issue of violence. So this couple worked with this counselor for about 7 months. And of course, the violence continued. It was not taken seriously. The couple was getting more and more frustrated because both the husband and the wife knew that things were not getting better at home. Finally, there was a temporary separation, and somehow this woman, obviously a fairly bright, this is a couple in their 30s, a very bright woman, reached out to the Assaulted Women's Helpline, which is a hotline offered here in the city that operates 24 hours a day. And she got the name of myself through that and came to see me. Immediately, I linked her partner up with someone who specialized in working with men. Within 3 sessions, that man was turned around. He was able to begin to see that no matter what she was doing, the violence was something that he had the power to control, and he would need to work on that. And we've worked with this couple for now just 3 or 4 months, and the movement they have made in about 6 to 10 sessions has been phenomenal. The violence has stopped. They have reconciled. Not that that would necessarily be the end goal, but the fact is for this couple, they didn't want the marriage to end. They wanted the violence to stop. And they were able to make extremely good use. The only difference between the kind of counseling they got is that myself and the person who worked with the man focused specifically on the violence to get that underhand before we moved on to look at anything else. And that was extremely helpful for both of them. The most helpful thing for the man, he was quite an intellectual fellow, and he needed to grasp some of the ideas in writing what was happening to him. This was a book, and I'm going to leave these 2 books here for you if any of you want access to them. This is a book written by my partner, David Curry, who wrote The Abusive Husband. This particular client found this really helpful. Now, it was actually a book written for clinicians, but it's also a very helpful piece of work for anyone who either is a batterer themselves or is working or having contact with men who batter. And for the woman, this is a book that she found extremely helpful. There are others written. I obviously am just sharing with you the 2 that I can give you. And this is Understanding Wife Assault. It's also helpful reading for any of you who want to do some more research on this area, because it gives kind of basic techniques that you can use, and also looks at what a number of the myths are and what the reality is in the lives of families where there is violence. So the upshot of this scenario for me with this particular couple, which are reflective of many families that we've worked with in the past, is that when someone is referred to someone who does not take violence as a serious problem worth primary focus on in their work, it becomes a very dangerous kind of intervention, and in fact can escalate violence. So it is better to have no counseling at all than to have counseling that's going to end up kind of covering up the seriousness of what's going on in the family. In terms of I want to talk just a bit about what the impact of violence is on women and children, and the whole issue around why women stay or return a number of times, and then go on to some of the custody and access issues. Do you watch?
Mm-hmm.
How are we doing for time?
Okay, you're fine, you're good.
Okay.
15 or 20 minutes.
Okay. If I were doing a half a day or a day-long workshop, I would take you through a couple of exercises to get you in touch with what it might be like to walk in the shoes of a battered woman. But if you can just imagine, if I were to ask you a question like, can you imagine a time in your life when you were extremely intimidated by something? Just maybe think of a time right now. Scared, felt helpless to control it. Perhaps it was a burglary in your home, or perhaps it was an actual assault, or if you can't remember something as an adult, think of a time when you were a kid and there was a bully on the block that you were terrified of and had to think of ways of kind of avoiding that kid in your daily life in order to survive, or a scary teacher if you were a little 6 or 7-year-old. Think of some of the kinds of feelings that you might have had in an experience like that. And can you think of any? Like, just call out what some of the feelings might have been? Anybody? Frustrated? Powerless. Angry. Scared. Trying to run, trying to get away. Paralyzed, immobilized, not knowing what to do.
Sort of wondering if it's ever going to end.
Is there ever a solution to this? Yeah. Yeah. Not being able to predict what's going to happen next. Exhausted from having to solve this problem. Loneliness, feeling very alone, no one's around to help you out, isolated. Yeah. Self-blame, a lot of looking at ourselves. And I had a burglary in my home the last year, and rather than be enraged about the burglary, my response was, obviously I didn't have the proper locks on my house, and the first thing I did was call the police in to give me a safety check on the house. And it's a pretty natural way to try to get back in control over a situation where you felt you've had no control. Well, some of the feelings that you've described are imagine multiplying that by the number of days, the number of assaults, the number of years that you have lived with this person, who, by the way, is no stranger. This is a person you've chosen to be your partner, to love, honor, and cherish. Your intimate has become your enemy, and you can have some sense of what the internal world is of the victim. She's usually very exhausted, very tired, very scared, fear is the predominant emotion that is going on for her. He's often made threats that if you ever leave me, I will kill you, I will track you down, I will find out where you are, I will remove the children from the country, I'll quit my job, you'll never get support. I see nodding of heads, so I'm sure some of you have heard these stories. And the truth is, working with the batterers, they agree. These are all of the things they have said and done in order to keep her there. Because the issue of assault is an issue of control. Actually, I'd like to read to you my definition of assault, which is possibly somewhat different than the criminal definition. It's been a workable definition for me in terms of actually working with these families. And the way I define it is that wife assault involves the intent by the husband to intimidate either by threat or by use of physical force on her person or property. And this is the important part. The purpose of the assault, and this is the only purpose, by the way, is to control her behavior by the inducement of fear. And underlying all the abuse that goes on in the home is a power imbalance, and again, that's a very important factor between the victim and the offender. No matter who the victim is, no matter who the offender is, there is a power imbalance there. And there are many forms of assault. Physical is the most obvious. It's also the easiest one to deal with, ironically, particularly, I would assume, in the justice system. Psychological abuse is as crippling and as disempowering to the victim and to the children as is a physical assault. Sexual assault is very common. Many women do not experience themselves as having been sexually abused, but it's a very common experience for many women. And the destruction of property and pets is another form of just a continuum of the abuse that occurs within the family. Abuse to the children is also another form of the abuse, although I'm not focused here specifically on child abuse today or even child sexual abuse. Clearly, they're very real problems. I'm focused more on wife assault. I think it's an important distinction to make in working with child victims within a wife assault family, to know that the abuse is often not directed to the children in order to get to the children. The abuse is directed toward the children as an indirect way of continuing to control their mother. And that is a particularly important issue to be looked at in the justice system, because that's where we get into all of the continued power abuses that get used through the justice system by the batterer, and how then the justice system becomes an extension of his fist, and the children are used, as opposed to the children actually being the primary victim, which is not to say that children are not harmed. But the purpose of the assault is to continue to control her. And she knows this. And she has heard the many threats about what's going to happen if she ever leaves, what he will do to her children. Okay, so when any of us, myself included, meet a battered woman, she may present actually as quite a together person, but it's important to keep in mind that what is going on inside, you're just seeing her public mask. What's going on inside is that she is very confused. She is terrified, she is scared, she is helpless, all the feelings you've identified, and she doesn't trust any one of us. And why should she? Because she is convinced that her husband is the most powerful person in the world, that no one else could possibly confront him because she's tried 6 ways from Sunday to fix up this problem, and any one of us is her last resort. And so she doesn't have much faith in any one of us. No matter what we say, no matter how much experience we have, she just doesn't have much faith in anyone who works in the system. And unfortunately, for some women, that's a good position because they haven't had much success in working within the system to deal with this. Many women will return frequently to work through this issue. Again, keeping in mind that the issue for her often is not one of wanting the marriage to end. And that's particularly important when a woman is coming to you as, say, a family law lawyer to find out what her rights are. She may come in prematurely to talk about divorce, when in actuality she is likely to be going on a roller coaster ride for probably quite a few months. And this is where you hear of the revolving door syndrome, and it's where many women are often blamed, and it's when many professionals get very frustrated working with her because they try to do good things, and then all of a sudden, all their work falls through and she returns, and they see that as a sign of failure. Remember, every time a woman returns, and she's had some outside contact with any of us and has gotten new, accurate information, which reduces her isolation, is she is going back to that situation, usually a stronger woman and a different woman than what she would have had if she had not left. So it's important that we view our interventions not whether she stays or leaves, but what is her ability to now protect herself? Can she protect herself any better? Can she protect her kids any better? Does she have new resources? Does she have new, accurate information? Does she have a better support system? And if you can say yes to any of those things, then you know you've done some good work. Even if it hasn't ended the violence, you know that you've done some good intervention. Because for her, it's a process of really coming to terms with, can this marriage work with just her making some changes? And in my experience, it will not work. But often she's not ready to hear that. She has to keep trying new kinds of things to see if he will come round to stop taking responsibility for the violence. In my work with batterers, I'm a firm believer for court-mandated treatment. Primarily because there's no such thing as a voluntary batterer coming for help. If you do have a voluntary batterer coming for help, and he's recognizing that he has a problem with his violence, then half the battle is over, because you've got an open guy sitting beside you saying, I've done this, I want to stop, I want to get help, I want to change. And that's half the work done. In my experience, I've had that maybe 5 times out of working with hundreds of batterers over the years. Most batterers come in a state of denial, and they come under duress, be it through the courts, which is less likely in Toronto, because we don't have many court-mandated programs. Usually they come because their wife is either left, and they're desperate, and they're scared, and they want their wife back, or because their wife is threatening to leave if they don't come for help. So they come in, they're pretty resistant, and I work with that. I really don't care how they come as long as they get to me. And so I begin to work with them very clearly around looking at, first of all, what they've done and how do they want to make some changes and how can they make changes. And I give them some very basic information, such as assaulting your wife is a crime. You can be prosecuted for that. It's against the law. And many men look at me astounded, saying, what do you mean I cannot hit my wife? Even in 1988, even with well-educated batterers, there is a belief that he is justified in doing what he has done because she has provoked him. She did not know when to let up. She talked to him in a way that he told her if she ever did that again, he would hit her. And of course she did it, and he hit her, and so he feels basically that therefore it's her fault. So that's usually the original position that he comes in with. It's her fault. And she comes in with the idea that it's her fault too. So you can see the difficulty in trying to make some change with them. However, when batterers turn around, when they finally begin to acknowledge that they can make some change, they move very quickly. There are people who believe that batterers cannot make change, and I'm certainly not one of them, because I think there's tremendous hope in working with batterers to make change. However, they will not come forward on their own. And the only way they will make change is if there is accountability in the community to force them to get help, to get there to begin with, and then if they have good intervention, they can make some movement. As far as how this affects custody and access, obviously the most common interim orders that women need to deal with originally, you know far better than I. It's the interim custody and access and possibly exclusive possession of the matrimonial home and the restraining order. I think that the main things in operation when we're looking at the issue of custody and access that should be uppermost in our mind is clearly the protection of all members of the family. Is she in a safe place? Are the children in a safe place? Are they going to get a time out to begin to pull their lives together to look at what the issues are? I also think that batterers are potentially very dangerous, either homicidal or suicidal, if they are left alone at the point of separation. Many people believe if the separation happens that that's the end of the violence. In my experience, the violence potential is dramatically increased at the point of separation, because the worst thing that has happened to him has happened. So he is even more terrified of losing control. So this is when you will find many men desperately searching the city for all the shelters and harassing family and friends and calling up workers like myself, or perhaps finding out who her lawyer is and calling and harassing the lawyer. Give me my wife back. The more sophisticated men don't do it in terms of wanting to get to their wives. What they use, well, she can go, I don't care about her, but I want my children. I have a right to my children. Well, there is truth to that, and that's where the fuzziness happens, because really, it's not the children he wants. And I'm basing this on work with many, many batterers who in fact are acknowledging that no, it wasn't the children that they were after, it was their wives. And that was the only kind of legitimate way that they could get to their wives, was if they could get somehow access to the kids. So the whole issue of our batterers, because they violate their wives, does that mean they cannot be good fathers? Does that mean that they should be totally removed from the children's lives? Of course, I don't believe that. However, I do believe unless he is held accountable for his violence and makes some change, he is not going to be able to be an effective parent. I would always work with a batterer to become an effective parent. Always. And if he can acknowledge his violence and make some change in that area, I think he has as much potential as any of us to become an effective parent. But that is a big issue these days in terms of access. Should access be possible for a batterer? Another issue that comes up is the whole issue of assessments. And I don't know what your success is around assessments. I haven't found too many people in at least the metro community who are doing assessments of families around issues of custody and access where they have a great deal of knowledge in the area of violence. And I don't think anyone should be doing family assessments where there is violence if they don't know anything about violence, because there is a very different dynamic going on in that family. It is not a normal power struggle that often happens between any of us who might have a family breakup. You're not sitting there dealing with two equal adults who each have a position of fairly equitable skill in negotiating. You're dealing with someone who is way up here and another person who is way down here who is scared to open her mouth for fear of what happens. They shouldn't even be in the same room. And I've had some assessors come to me who are very intimidated by the batterer, don't know how to deal with him, and so are trying to settle the case quickly to get this guy off their back. Has nothing to do with what's going on in the best interest of the children, or even in terms of him, because what's happening is they're just playing into his own belief that he is this kind of, outwardly at least, all-powerful person, which of course we know he's not. So that's an important thing around assessments. And if any of you have people who you find particularly effective in doing this, please give me their names, because I am desperate to find some in Metro. It's a real lack. Around mediation, I have done mediation myself. I do a lot of family work where there is no violence, as well as kind of what I call normal marital counseling. I have not found mediation to be particularly effective in the case of violence, unless the violence has stopped and unless he's been able to acknowledge his responsibility in the violence. Again, for the very same reasons as to why assessments are not particularly effective unless it's an experienced person, because we're working with such a differential in power that there is no possibility for real negotiation from a true spirit of goodwill or a movement of a couple to look at what is the best interest of the children. Around the issue of access and rights for the batterer, my experience is that he usually is seldom sincerely interested in establishing good parenting relationships with children, but tends to use his right as their father, again, I mentioned this earlier, to gain access to her. And unfortunately, especially for middle-class men that I've worked with, the justice system becomes one way that he can continue to abuse her through the use of a tremendous amount of litigation. I've worked with a number of women and batterers where they have, it's just a dance, a revolving door syndrome where they are in and out of court all the time. She might charge an assault and he does a counter assault, and I usually get both affidavits on my desk, and if I didn't know about the issue, I would have a really hellish time trying to figure out who was telling the truth. Often her resources are drained. She's exhausted, so it's very difficult for her to do any decent parenting. The children are tired and fearful because this has sometimes gone on for years with no settlement, because it is not something that he necessarily wants to settle. It is something that he is just continuing as a kind of a legitimate legal form of harassment. And unfortunately, if he could have been held accountable much more earlier on in the system, he might have really been able to turn his life around and in fact become quite an effective parent, assuming the split was going to continue. Unfortunately, the cases where you hear this going on all the time, sometimes they are so far down the road that it is not repairable then by counseling. Although I think good counseling that is mandated can still assist him in trying to rework his potential in terms of reopening the whole issue of parenting relationships for him. To allow you to talk, I'm going to finish. I'm trying to summarize about 2 or 3 days of training in very few minutes, so if I'm all over the map, I'm sorry. I'm trying to get some of the essentials out. I guess my bottom line is that in terms of good legal intervention, I think that it really needs to be therapeutically sound for all family members. If something is going to work for one person and it's done effectively, it will work for every member of the family indirectly. So if there's a sense of two working against one another, then really no one is going to be effectively assisted. That safety and protection has to be paramount for all members of the family, and that clearly the responsibility of the violence needs to be placed where it lays, and that's with him, and he needs to be held accountable for that. So thank you, and I think Heather would like to take some time.
Well, I think my comments are going to be probably less illuminating because we're all lawyers and we all start from a certain framework, but I would like to save some time for questions. I think there's going to be a lot of time in the custody workshop, but there may be some of you who aren't going to come to that and may have things you want to discuss. I'm always glad to come to these seminars. I'm always glad to get asked to do a paper, although I fetch and moan about it endlessly because it's a lot of work. But the reason I enjoy it is that it gives me a chance to step back and look at the broader picture, or look at things different than drafting affidavits for interim motions or figuring out how you file something in Brampton. It gives you a little bit of a long view on the whole area. And I think in terms of custody and access issues in cases where there are violence in the family, I think we have to all step back a significant distance, those of us who practice in the family law area, and look at some of the very real truisms that are thrown up at us day in and day out by ourselves, our colleagues, our clients, judges, masters, everyone who works in our world. Our world gets very narrow, and I think one of the advantages of this exercise to me was to step back a bit and say, well, wait a minute, why am I saying this? Why am I saying that? In trying to do the paper and in trying to prepare my remarks, it really became clear to me that I was having to take a look at a lot of my preconceptions, my ideas. Even though I worked extensively for 5 years representing women who were victims of violence, a lot of my own social biases, my own social ideas, my own social theories, which are not going to be endorsed by Harvard or anybody else, were all coming to the fore. And I think that goes on with all of us without even knowing it. And it goes on with our judges and our masters and people who are, like ourselves, interested in this area and try to educate themselves. And I think we have to take a look at that. I'm not going to talk, as I said, I don't want to talk about how you draft affidavits. We can talk about that in the workshop if you don't already know how to do that. I'm assuming you all know how to do that. But in the paper I wrote, I tried to look at one misperception in particular and how it affected custody and access, which was the idea that the father could hit the mother and that had no bearing on his ability to parent the children. And that's just an example. I'm just raising that right now as an example of the sort of thing we hear all the time. And in the paper I gave some ideas about how we might confront that, what type of expert evidence you might want to look at, and just educating ourselves generally on things like the impact on violence in the family. Does the child have to be the primary focus? I think Deborah's comments are quite important because it's clear that the children may well not be the primary focus, but they may still well be victims of the violence in the family. And I think that's just an example of the type of misperception we have to be prepared to confront and deal with. There are others that I want to talk about right now. And I think one of the primary ones, and one of the things that makes these cases particularly difficult for us as practitioners, is that in the last 10 years, there's been a tremendous movement that was alluded to this morning towards settlement as the end goal, the optimal goal for all families in all situations of marital breakdown. And custody disputes and custody issues have been leading the charge. We've had mediation, negotiation, assessment, all of these types of private mechanisms put into place to come up with a private agreement and keep these disputes out of the court. And there's been a real pressure from, I think all of us who work in family law are probably settlement oriented, because in the majority of cases, a settlement is going to benefit the family rather than having them spend the entire equity in their matrimonial home fighting on something that could really be resolved in a much more efficient way. But I think you have to stand back and say, do I handle all my cases exactly the same way? I think the answer to that has to be no. Different types of cases require different approaches. And when you're handling a case in which there's been violence in the family, I think you have to get out of the lane you might ordinarily want to travel in, where you do a lot of diversion in custody and access disputes. I refer people in many families for mediation, and I'm quite pleased with the results. I have many people who are referred for assessment, and I'm generally satisfied with the results. But these are cases where there is not violence, there is not an unusual pathology, and I think you have to take a different stance when you're handling a case where there is violence. The general reasoning, to paraphrase some of the research that was done, is that you should settle custody disputes. They shouldn't go to trial because, I wrote this down, the hostility between the parents continuing after the separation is going to be worse for the children than the actual separation. And again, I'm not a psychologist, but that's what I gleaned from what I've read. And this leads to the theory then, well, then you should settle your case because a trial is going to make everyone very hostile. Someone's going to win, someone's going to lose. You're going to have an imposed settlement that no one is happy with. It won't be custom fitted to this family, and therefore we should all settle. And generally speaking, I don't argue with that reasoning. As I say, in the vast majority of my cases, I don't argue with that. But in these kind of cases, I do argue with that. I think we have to step back and say, why am I trying to settle this case, or what is going to be gained from her position as the battered spouse? How is she going to feel in these negotiations? What do I have to gain at each step? I think we always say that the quality of the settlement is the issue, not the fact that the case is settled. And I think the quality of a settlement for a battered spouse is significantly different than in an average family. If you are always anticipating that you're going to be settling your case or that it should be settled, it'll affect the decisions you make all the way along the line. It'll affect the advice you give your client. It'll affect how you feel about the case, and it'll affect it generally. And again, I'm not saying we shouldn't settle our cases, but I'm saying we have to be particularly careful in these kinds of families because you're dealing, as Deborah said, with issues of control, which have significant impact on children and on the custody issue generally, and you're dealing with a power imbalance. In the paper, I talked about my concern that there really wasn't an acknowledgement on the part of courts and the system we work in of the significance of violence in a family, and that led to statements like, well, he didn't hit the kids, so what's really the problem? And you combine that with the pressure we all feel at pretrial conferences and just generally to settle our cases, and I think it can have a particularly devastating impact in these families. It makes it very hard on us as the lawyer because we suddenly become the problem in the sense that if you have a spouse, a battering spouse whose lawyer's coming forward who said, look, my guy was willing to do anything, he would have gone to marriage counseling, and we're all standing back and saying, well, Deborah says they can't go to marriage counseling, so no one's going to marriage counseling, so you're a problem there. Then they separate, then you're the problem because you're not going to mediation, because you know, and I think rightly we know that it's not necessarily going to help these people. Then you're the problem maybe because you can't agree on an assessor, because all the people he's putting forward are people you don't think have any particular expertise. Then you're the problem because you fought it out over access when all he wanted was reasonable access on reasonable notice, and you wanted times and dates and places and witnesses and everything else. So you look like maybe you're as paranoid as your client. And it just goes on like this. And we become, the perception is that we become part of the problem. And I think as practitioners we have to stand up to that and feel, and part of the purpose of today I think is for people who work in this very difficult field to feel there are other people experiencing the same thing. We're not part of the problem. We're doing the right thing. We're doing a good job for our clients. But I think we're fighting an uphill battle because the pressure is all coming the other way. Then you get through all this. You've had your pretrial that went on for 6 days because they wouldn't let you out of there. Finally, you get out and the issue at the pretrial was that you wouldn't agree to joint custody. And I think even in normal family disputes, this is becoming a really serious concern. And it's hard to explain to some lawyers and some commissioners why you're going to kick up a fuss at joint custody. What it'll take to settle this case, this is again just an example, is joint custody. Give my guy joint custody. You can have decision-making power, but he needs that label. Well, again, it's easy enough to say, well, what am I getting in this deal, and what am I giving up if your alternative is to have a lengthy, expensive trial? I know there's people here from legal aid, and for what it's worth, in my opinion, it's worth going to trial on the issue of joint custody in cases where there's violence in the family. You can all quote me. It'll have tremendous impact with legal aid, I know that. But, you know, this is becoming a really serious issue. And even if you've fought it out, you've got the access, you're now a year after the separation, you're in sort of a holding pattern, that's sort of the last straw that comes down for negotiation. Joint custody, as I say in my other cases, can often be a very good thing. It can be a terrific thing. But it can also be a tremendously threatening thing, even to my reasonably well-adjusted clients and who have been primary caretakers. And to a battered spouse, it is really one more knock in the chops, I think. And again, I often get it thrown in my face when you're talking about punishing behavior and rewarding behavior. I don't think that's where we're at all. You can look at the mother's perception that maybe this is another type of assault on her. But again, we have to focus it, get away from that, because no one will listen to that, and look at what does it mean in reality for the children of this family. If you have a client who, even with joint custody and even with all kinds, I mean, I once did an agreement that was 28 pages on parenting. It was a joint custody agreement. These people could obviously agree on a lot. And it was 28 pages long. You know, it covered stuff like who would take the kids for haircuts, who had birthdays, who gave birthday parties. It was absolutely ludicrous, and I regret to a certain extent having done it now. But if you have a client who, even with 28 pages of stuff telling her what she can do and she has the power to do, but she doesn't feel that and can't use it and will not feel effective, then what good is it? And if you have on the other hand, you have a spouse who, no matter what label you give him, is going to feel he needs more power than he's got, then who are we helping with this one particular label in this example I'm giving you? The client may wrongly look at the label as something that will empower her. We may know that there are husbands that, even with access, even with no access, even with restraining orders, who are going to continue to be infinitely inventive about how to make their spouse's life a screaming hell. But if that's the case, if you're really dealing with this person, then why are we helping him by giving him joint custody? Why are we then saying, well, you can have joint custody, it'll make you feel better, but in effect we're going to try and make it not a meaningful joint custody because we're going to give this other person all the power? Why is that sensible? And again,
can I
sorry.
intervene from a
Sure.
batterer's point of view?
Sure.
In working with the men I've worked with who have what I would say recovered, made movement, stopped being violent, this would be a perfect example of what they would say, how the system kind of played into their own denial of their abuse and how the system did not hold them accountable, even though often they were...
What gave them too much too soon?
Gave them too much too soon and kind of fed into rights which they knew down deep they really didn't have. They knew they were continuing the struggle.
Oh, and I think what Deborah's talking about is to the extent that our system does not confront and make people acknowledge the responsibility for their behavior, which I don't think it does particularly well, to that extent it just increases their omnipotence and increases their willingness to continue their behavior because they've never been yanked up short for it. So in this example, I mean, again, I'm talking about a case that I don't think is uncommon. You may have, as I say, slugged it out early on. Things are reasonably okay. They're not wonderful, but he's still undermining her and all like that. But you come down to an issue like this, and there's I feel a tremendous pressure to settle this case, settle it up for joint custody. And I think you have to step back at each stage and say, what am I getting for my client with this? Isn't this just another potential experience in powerlessness for her? In the long run, in a case like this, where you settle it up and you do give joint custody, just as a further extension, and we all know this from our own experience, if you make the wrong settlement, or a premature settlement, or a settlement where your client is really not, it's really screaming and yelling, and it's not a good thing, we'll all be living with it for the next 100 years. And for your client who has been the victim of violence, it is going to be extremely difficult for her in the future to unravel what she's already done. She's acknowledged him as a joint parent, and her ability to perhaps go back to some of the things she could have relied on at the first instance as things that qualify his parenting or make him a limited parent are perhaps going to be lost to her. There may have been no material change since she signed the agreement, and that's what she's horrified about, is that she signed the agreement. He's still behaving the way he always did, and you may have lost your ability to go back and get all that original evidence in. Certainly by then you're so far down the road that whatever status quo arrangement you have is going to be pretty entrenched. So I'm just using that as an example of how we all, I think, get inexorably into the flow of our cases, the flow of our work, and we hear things and we say things and we don't really question them. We all say, well, trials aren't good for kids. Worse things can happen to children than they go through a custody trial, I think. I'm not saying that flippantly, I'm not saying it lightly, but I'm saying you have to evaluate what the cost is. Is having a trial in this case going to be so overwhelmingly awful that it's worth this settlement? I guess that's what you have to ask. But to just glibly go on the way we all do, saying, well, trials aren't good for kids, you know, that limits where you're at. That inevitably limits your options. The other example that I thought of was in the case where you're acting for a woman who perhaps does not have her children. And I was particularly struck with the case I got from, I can't remember what they call it. It's in my paper, the National... I'm sorry, my mind's gone blank. Whose paper do I have? Whose case do I have? The case from Nova Scotia.
Louisiana?
Yeah, it's the Rago case, but I'm trying to remember where I got it from. My mind is a blank. But it's in the paper, and it was reported in the newsletter of this nameless organization that I can't remember, that I subscribed to. And I was particularly struck with that case because this woman fled violence without her children. Her husband, I believe there were at least 2 kids. There may have been more, there may have been 3. And she got into a shelter, and then all the typical things that we all know about started. She couldn't get interim custody of the children because she was out of the house, had no means of support, and had no housing. He was in the house, the kids were going to school. What Deborah said had started, which was the kids were allying themselves with him for survival reasons. He was providing for them. He was also in the conciliation mode where he was buying them things and really treating them well. So she loses interim custody. She fights it at trial. There's quite an extensive trial where expert evidence is led because, again, at this point you're looking to dislodge a status quo which had gone on for quite a while. And you're also looking at trying to prove what the long-term effects of this relationship on these children is going to be, on him as a batterer and him as a custodial parent. And they led some expert evidence, but again, it was not, it wasn't well received by the judge, which is unfortunate. They led, I think the evidence they had was the head of someone who worked in the Nova Scotia government who established shelters for battered women, and they had someone else who worked actually with this woman. They didn't have any big names, they didn't have any big PhDs from some other place. And the trial judge made his decision almost totally on the basis of status quo. He did not deal with the expert evidence, he did not refer to it, he did not deal with the fact that this woman had had enormous problems getting access to her children. She had not had very meaningful access since the kids had gone to live with him. And when you look, and then she appealed it, and unfortunately lost on appeal because we all know appeal courts think trial judges see the evidence and therefore see more. And again, I think it's not an uncommon scenario. I think we've all acted for women who've not had their kids from the beginning, and we've all been faced with the issue of status quo. And it's a truism. It's another truism. You'll go on your intramotion, status quo, very important, you can't move children. So I think, and again, we all accept that on some level. Yes, it's very disruptive to children to move them, 50 times. But on the other hand, I think you have to say and be prepared to form your case. Worse things can happen to these children than that they get moved. There are worse things that can happen than that simply a move. People move all the time, whether they're married or not. They move. People come in and out of children's lives. It's one issue, and it's only one issue. And I think if you're dealing with a case like that, you have to be very well prepared to address that argument. And to the extent that our judges and courts simply parrot these kind of truisms, I think it's a reflection of the fact that they don't acknowledge the significance of violence in families. It's a circular kind of thing. They will find a truism that they can rely on, because then you don't get into confronting the major issues. The only other point I want to make is that I think, and I hope I made this point in the paper, is that I think we have to reframe our cases in many ways, and I think this is particularly important. As Deborah said, violence in a family is an issue of power and an issue of control. And if we have to reframe our custody cases to focus on that, if you've got a person, a batterer, who has a need for control, a need for power, and is prepared to use violence to get that, I would think, in my limited experience, I would think that would have some implications for his parenting. But to the extent that you sometimes focus your case on, he hit her on October 6, 1978, he hit her on November 12, 1972, he hit her again, that doesn't answer that. That gives you the specifics of the assault, which is why she may be feeling the way she is. But you have to look at it in the broader context of what it means for the children, because if you're going to be answering that question that he didn't hit the kids so he can't be a bad parent, this is what you're going to need to be able to show. And I talked in the paper about trying to find experts trying to use that. But I think it's a question of reframing on all levels, that we examine what we ourselves are saying to our clients, we examine and be prepared to confront what the courts are saying to us, because there's a lot of misinformation in there, and there's a lot of underlying bias in there that isn't as overt as it used to be. But those are the comments I had. I know we're supposed to be finished, but I'm prepared to seize the microphone and have people ask questions for a few minutes if anybody has anything they want to say.
All of this is primarily addressing physical violence, and I was wondering if you could make any comments on what's appropriate for the violence strictly emotional or psychological, where there's no gathering of the wife, but there's constant threatening, belittling, this sort of thing. How do you deal with that?
I think in my comments I was referring to violence that incorporates physical as well as psychological, sexual, and to property, pets, and children. So I think the dynamics are identical. It's still an issue of control and trying to induce fear. And for some men, they feel that they don't have to go that far to use physical force because they are able to be quite effective in controlling her using psychological. And they also don't have to, because they are able to keep her kind of terrorized using psychological means, threats or a number of things like that.
What do you do to find out?
Much tougher to prove. It's not that effective even when you have physical proof, unfortunately. So yeah, when it's psychological, you're looking at a much more difficult case, no question. I think in terms of my therapeutic interventions, they're identical. Whether I would work with him or with her or with the children, the impact is the same. But when you look at the justice system, it's certainly
a much
tougher.
harder case.
Much harder case. Especially to put the light label battered woman on her. Yeah.
In the back? That's you.
Deborah referred to the phenomenon of children identifying with the powerful battering parent. What practical suggestions do you have when you're facing a trial and you have older children who are identifying with the powerful battering parent?
I would say get an expert witness in who has a tremendous amount of experience around looking at what the impact of violence over a long period of time has on children, and not put the children, if possible, on the stand.
I think, again, the other thing you would like to be able to do is get an assessment that identified that dynamic. And I guess if you felt that you had someone you were comfortable with who would be aware of those issues, you could also start with an assessment, because there's obviously a distinction between generalized expert evidence and expert evidence about this family. And you may run the risk of the generalized expert evidence not being admitted, either as being irrelevant because you haven't proved that this is a battering family, or for a number of any other reasons. So if you can find someone you're comfortable with, who hopefully will identify that, then you'd start there working with this family. If you can't do that, then I think Deborah's right. You have to find someone who can give generalized evidence about what children go through and how they deal with it. You're then left with the question, you've got these over-identified children, what then is the impact on shifting them? And you have to go further.
As a counselor, in my role in that family is that it's not unusual at all for me to see children, especially older children, the oldest kids in the family, to become abusive towards their mother particularly. And not only do they identify with the aggressor, they become an extension of the aggressor, the offender. And then you're dealing with parent abuse as well. So it gets very complicated because these kids have been pretty brainwashed. And sometimes I have to work with the woman to let go. And if I have access to the kids and can work with them, I work with them in the identical way I would with a batterer. Hold them accountable. I work with the mother too. If she's got a 16-year-old son who's assaulting her, and the husband perhaps has left the home and he's continuing the abuse, I work with her around getting assault charges laid, and treating it. Trying to get the kid into treatment, treating it the same way as I would with a batterer. He's got a greater chance when he's 16.
Penny?
I've heard many people make comments that once battered, always battered, and the ability to make a realistic change is very minimal. How do you work so effectively with these batterers? I know you want to get a few seconds, but what did you say to these people to stop them from doing it?
Put the fear of God into them. Well, see, I think people who believe that don't work with batterers. Because I don't think you find too many of us who actually work with batterers who would say that. I think what we can say is that there's no research out long term to know, and we have no longitudinal studies to follow these men for 10, 20, 30 years, or that we have no control to find out how they are in their next relationship, for instance. When I talk about success, I'm talking in terms of kind of intuitively working with him to know that there has been a very clear attitudinal change in him which affects his behavioral change. And I can sense from the way he now talks about not just his partner, but for instance women in general, and the way he talks about himself, that he has made some significant change. That's what I mean by his ability to begin to acknowledge his violence. I also don't see him as a jerk, and that makes a big difference in terms of bonding with him. I see him in many ways as a victim of in a broader sense than obviously her, of a society that believes that